Good day. We recently employed a sales representative who used to work for our competitor. After employing him, his ex-employer went to the court to enforce his restraint of trade, which they have successfully done. The employee now refuses to resign. How do we go about terminating the employment?
What do you say, Yaku? What do you do?
So it's quite an interesting question in terms of the resignation of the employee. Let's first deal with restraint of trades. So restraint of trade is actually more a contractual law principle rather than a labor law principle, although it plays out in the labor field. And it's obviously to protect the interests of the ex-employer, especially where it's a niche market, where they've got trade secrets or specific clients they market to. So restraint of trade would normally say you cannot go and work for my competitor type of thing. And then when that is enforced by the court will determine whether it's reasonable, and that is normally determined based on essentially two principles. The first being that public policy, it's good for public policy or public interest rather, that people should comply with their contractual obligations. The second portion is the constitutional right to freedom of trade and occupation and to be productive in society. So those are two competing interests. So in this case, it seems that the court found that the restraint of trade was reasonable and enforced it. So I'm battling to understand the resignation part, because in that case, the court will say, well, I'm enforcing the restraint of trade. You are not entitled to take up employment with a new employer in terms of your contractual obligation.
But now he already has.
Well, he couldn't have. He would have been interdicted to do so. So that employment is terminated by virtue of the court order.